pledge allegiance
allegiance to the flag of the United States of America and to the republic for which it stands, nation, indivisible, with liberty and justice for all.
Okay. So our first item, Jan will become a regular voting member.
First, take attendance.
Oh, sorry,
That's okay.
attendance. So Jean, I'm here. Jesse?
Here.
Mingo?
Absent.
Nikki?
Absent.
Kevin?
Absent.
Jan? And Ray?
Here.
Ray?
Okay, now you can
Okay.
do that.
All right, so we have a change to the committee. Jan will become a regular voting member in place of Kevin Gendron.
Or you know what? Let's put him in place of Nikki Colley because tenant to tenant.
Okay, in place of Nikki.
Okay,
Good idea.
Okay, and that's for this meeting.
this is for this meeting.
Okay,
Mhm.
so we have a quorum to continue. The minutes were mailed out. Thank you very much, Lori. So at this point, I need a motion to accept the minutes,
Approve minutes
approve the minutes
of the June 15, 2023 special meeting.
of the June 15th, 2023 special meeting. Is there any discussion from the minutes? Any changes? No? Okay, then the minutes stand as approved.
All in favor?
Oh, you should vote all in favor.
You could say aye.
Aye.
Oh, hey, Ned, I have one question. Should we put Ray in place of anyone since he's on here too?
Well, there's two things. One, just be cognizant of the Democrat Republican breakdown. And number two, always try to replace a like with like a tenant with a tenant, and landlord with a landlord, if possible. Okay. Yeah, name if you're filling if there's two alternates and there's two vacancies for the meeting, you fill them with both alternates.
Right. I just saw that. Sorry for the.
That's all right. The chair can appoint the second alternate in place of the remaining member. I'm not sure if it was Kevin, or I'm not sure if you switched that or not, Laura.
Yeah, he could be in place of either Kevin or Mingo, either one. You could do it in.
Well, what is Jan? Wasn't Jan appointed in
Jan is appointed in place of Nikki Colley, tenant to tenant.
Okay.
Okay, so we have the Republican, and then we're gonna do Ray in place of Kevin Gendron, landlord to landlord.
All right, that's fine.
Okay, so you
Yeah.
could say that.
Okay, and then at this particular meeting, Ray will be a regular voting member in place of
Kevin Gendron.
Kevin Gendron.
Okay,
And Jan will be a regular voting member in place of Mingo.
in place of Kevin Gendron.
You said that right.
Wait.
Let's do them again.
Yeah, Jan is in place of Nikki,
And
Ray's
Nikki,
in place
okay.
of Kevin.
And Ray is in place of Kevin.
Okay, so now we could take our voting. Yeah.
Okay, so we have a motion to approve the minutes as published.
I think you did that already. I think that was already voted
We
on.
did Jan and Jesse.
Okay. All in favor? You all voted?
All in favor?
Aye.
Minutes are
So
accepted.
3, any opposed
Any opposed?
and any abstentions?
Any abstentions? Abstain, okay.
Okay. See. Let's see. And, yep.
Okay,
Yeah.
we're gonna move on to new business. the primary focus of this meeting tonight is for training.
There's a sheet over there. Okay, so
Okay,
at this point, should we take Jan off of the regular voting and put Nikki back
Yeah.
in? Ned?
Wait, say that again?
Okay, so Nikki Colley just arrived.
Yeah,
we
so
put
she
her
will
in?
resume her place in lieu of the alternate who has been named to replace her.
Okay,
okay. All right,
But
so,
it has to be, provided there's nothing pending, no vote pending.
no vote pending.
Okay. Very good. The chair can note that.
Yeah, so we could put him in for, well, we don't have any more votes to do, so we're good.
okay, all right.
Come on.
Okay, Rachel. Okay,
Right, so, Nikki is our meeting and
okay, now we'll just move to the new business A.
business, yep. So the meeting, we're gonna transition to training and Rafi is going,
Rafi
Rafi, sorry, Rafi.
Delsky, you're on, Rafi.
Okay, thank you. By the way, whatever it turns out, it's close enough in terms of name. First of all, I want to say thank you for inviting me to come. The part of my immediate background in this is that I was involved in the statute that essentially required that larger towns have fair rent commissions. So I had some sort of fairly direct history in the expansions of the last year. But let me tell you what I do and my connection to this, and then let me say this first. My name is Raphael Podolsky. I'm a lawyer. I've worked for the legal aid programs in Connecticut for many, many years. And my specialty has been housing. So I come to this from a tenant perspective. And I'm a homeowner. I'm not a tenant, but I certainly bring that perspective to fair rent commissions. The Fair Rent Commission statute was first adopted in 1969. So we've had fair rent commissions for a long time. The number had leveled off by, I would say, probably the early 1990s at somewhere around 22 or 23 towns, and then kind of stayed level for a while. And then the statute is now going to bring it to over 50 towns that will have fair rent commissions. And like you, they're putting commissions into place. And for a lot of people, it's like working from scratch, because as a new commission, you don't necessarily know anything about it or what it does or what it's supposed to do or what it used to do. Even in some of the towns that have had fair rent commissions since the 1970s and 80s, there was a period probably from the late 90s through about 2015 or so, in which rents were very stable. And the result was complaints dropped. And so you had a situation where some towns were getting almost no complaints. And then over time, you end up losing the membership you have. And now having to appoint new membership, the old staff is gone. You don't have municipal staff that you had before. You have new people. So for a lot of people, even the towns, some of the towns that have had fair rent commissions for a long time, they're starting over in some sense, just as the new towns are starting from the first time. So I was a member of the Hartford Fair Rent Commission in the 1980s, the early 80s. I live in Hartford. I was on for, I think, about 4 years. And because Hartford then was, I mean, it's a bigger city, but it also has a large rental population. And it was a period of rapid rent increases. We had lots of cases. I mean, we were pretty much meeting weekly, and we'd have 3 or 4 or 5 cases each week. So I had a pretty fair amount of experience with the Fair Rent Commission when I was on it. I have not been on a commission since then. I have not been in front of a commission since then. I've talked to a lot of people, but so I have some genuine experience-based knowledge, but it's not necessarily current. And I guess I want to say these things to you so you know. What I'd like to do is take a little bit of time and say some things about what fair rent commissions are and what they do, and then essentially stop and let you ask questions. Originally, a second attorney was going to come with me. It was Sarah White, who works at the Connecticut Fair Housing Center. She had ended up with a conflict tonight and couldn't come, so I'm here without her. But I think our perspectives are fairly similar, and we were both involved in the drafting of a toolkit, which included a fairly extensive Q&A plus a model ordinance. And with the cooperation of the Connecticut Conference of Municipalities, our model got circulated and has been, to one degree or another, adopted by, I would say, most of the new towns, certainly not all of them. And towns are free to do anything as long as it's compatible with the Enabling Act. So what I'd like to do is kind of hit 4 major questions that I want to say something to you up front about, and then essentially leave it open. You can ask me anything you want, and I'll stick around as long as you want me. Is that okay? Does that work for people? Right. And I'm not bothered by questions that kind of interrupt a presentation. I don't feel compelled to get through the whole presentation, which I think will take maybe 12, 15 minutes. But I'll stop at any point. So if you have questions, you should just interrupt, and that's fine. I don't know, raise your hand or just say something, and I'll try and stop. First of the 4 questions is, what is a Fair Rent Commission? It's a municipal board. It's a municipal board in the same sense that, say, a zoning commission is a municipal board, or perhaps the zoning board of appeals is a municipal board. It has decision-making powers. Lots of times, cases that start don't get all the way through because they get worked out in the process. And that's actually one of the beneficial functions of a Fair Rent Commission. But ultimately, you're a board that has the power to make decisions, and you make those decisions in individual cases. So there's a sense in which you're acting like, sort of like mini judges. I mean, it's a quasi-judicial administrative function. My feeling is, and not everybody agrees with this. Actually, not everybody's going to agree with everything many things I say probably. But the commission functions, I believe, as the conscience of the community in regard to matters of rent. And the reason I say that is you ultimately are enforcing a standard that's based on unconscionability. The ordinance and the statute talk about rental charges being essentially excessive to the point of being harsh and unconscionable. And I mean, you can translate that into other language, but to me, it means something about them really seems unfair and offensive. And that's kind of ultimately what you're applying. And one of the reasons this is not a single member quasi-judge is because it's designed to allow people with different perspectives to look at the situation, look at all the elements of the situation, and essentially come to a conclusion that says, this is fair or this is unfair, or maybe this is really unfair, and it really needs to be fixed, and we have the capacity to fix it. And that's really what you're doing. So decisions by a commission are often very individualized, and go to the circumstances that they've learned about through the hearing. That doesn't mean there aren't some patterns where, as you hear multiple cases, you get the sense that certain kinds of things rise to that level that require your intervention. And your intervention may be with different degrees. It's not always the same intervention. And some that you think just don't rise to the level that you think you should do anything. I mean, and that's, and I'll come back to that in a second. So what you're looking at sort of this sense of unfairness. And part of the underlying goal is that fair rent commissions are a form of what I would call rent stabilization. That's to say, they're not they don't regulate the market. You are not deciding what everybody in Naugatuck can charge for rent. What you're deciding is really under what circumstances do you want to intervene to make it possible for an existing tenant to be able to continue to live where they live. You're stabilizing people in place by preventing them being driven out by whether it's rent increases or unfair maintenance or other things that would otherwise might force them to move, or might force them to continue to live in conditions that you really think are unsatisfactory. So that's question number one. Question number two is, what can the commission do? If it finds that if it comes to a conclusion, and all these are ultimately by majority vote, but comes to the conclusion that something must be done. I mean, one conclusion is nothing should be done, and that means the tenant loses the complaint. But if it comes to the conclusion that something should be done, then the question is what? What is it you can do? And there's a lot of discretion that the commission has, and you can mix and match the common solutions. The most common solutions are, number one, you can roll back a rent increase. Or you can roll it back all the way. You can roll it back partially. You can roll it back. You could roll it back even before what it was before the complaint came in. Most likely, if you felt that it needed to be rolled back, you would end up rolling it back either all the way or part way back. You can also condition it on certain conditions being met. And this is quite common. Tenant says, I don't mind paying this rent increase, but I've been complaining about a bunch of things for weeks and weeks and weeks. The landlord won't fix anything. Or the city has been out and said they're housing code violations. The landlord doesn't want to fix them. One of your options is to say, well, this rent increase is not unfair inherently, but it's very unfair if the landlord isn't complying with the code or is not making obvious repairs that should be made. And so you end up saying, you can landlord, you can have the rent increase as soon as you do X, Y, and Z. But until then, we're going to keep the rent where it is. Who's won that case? Well, they both won in a sense. The tenant got a hold on the rent increase and the tenant got the repairs made. But the landlord ultimately got the rent increase. He just had to do something that the commission felt was reasonable as a condition of getting the increase. You can do things as a phase-in. It's very common where you get very large rent increases and tenants come in. Somebody's rent is going up $150. And the commission may decide, well, if this had been a $25 or $30 rent increase, it would be no big deal. Or even if there was a year to work your way up to this increase, that would be okay. But not all at once. That's too much. And so you end up with a situation that says, well, you can have $30 now and $30 more in 6 months. Or something, and it might ultimately take you all the way to what the landlord was asking for, or maybe it doesn't go all the way to what the landlord is asking for. It stops at some point in caps. That kind of thing is very common. You can well, actually, those are really the big things. Either there could be no increase, there could be a phase-in, there could be the full increase. It might be conditioned or it might not be conditioned. So those are the kind of the things you work on. It's interesting to note that the statute does not simply talk about rent increases. It talks about rental charges as being essentially disproportionate to what the renter is getting. And that's one of the reasons that this keys on in a lot, especially in the bigger cities, with housing code enforcement, because you end up with situations where the landlord has not complied with code orders from the code enforcement agency, and the landlord is simply resistant to complying. And the commission is in a position to now key the rent increase, either full or in part, to compliance. So, particularly in towns where code violations are a significant issue, you see a lot of orders from the commission that are conditional orders that essentially back up the code enforcement agency and become sort of a tool to get the code agency's orders enforced, because the landlord is going to be told you can't have a rent increase until you comply. And then ultimately the landlord complies. The commission can also has the power to protect complainants from retaliation. And that's something that's really important, because you're not going to get any complaints if tenants feel that they're going to get evicted if they complain. And it's not unheard of for landlords to threaten or actually engage in eviction in order to get rid of a tenant who complained. So that power that the commission has is important. The third question is, what is the standard? And the statute lists 13 specific standards, which I think are in your ordinance itself. They were written in 1969. Some of them are a little bit quaint, a number of bathtubs or toilets or something like that. But we've grouped them for our purposes into what I would call 6 categories. That the statute does not say which is most important. Its statute basically says it's your job to weigh them and figure out how you weigh them. And they may not all apply in all cases. So this is what I would use is the way I would group them. One is the size and the history of the rent increase. How big is the increase? What has happened in the past? Is this one of a sequence? Is this the first increase? It may make a difference, but size makes a difference because requiring a phase in or limiting the size of an increase is one of your possible solutions. The second one is how much it's costing the landlord. What are the landlord's operating costs? How much is it costing him to run the building? Does he need the increase? You cannot expect landlords to run buildings at a loss. And so that's a significant factor. It's not the only factor, and it may be balanced by other factors, but it's certainly a significant, important factor. A third factor is what are the conditions of the premises? Are they being maintained in an appropriate and proper way, or are they not? Because that may affect how you feel about a rent increase. The fourth grouping that I would say is comparable rents. And this is a tricky one. What are other people paying for something similar out there? It does not follow how, and it would be very common to justify a large rent increase by saying a unit is underpriced. And it may be, but that doesn't necessarily mean standing alone that justifies a rent increase. It may, but also may be counterbalanced, say, by the size of the increase, which is also a factor, which may then lead you to say, well, this can't be done all at once. These are all balancing things that you're doing. There's a tricky thing about comparable rents that I would just warn you of. There is a difference between the rents that existing tenants pay and the rents that are asking rents for new tenants. And you are always looking at existing tenants. You are not setting a rent for new tenants. You're answering the question as to whether this rent is excessive for existing tenants. So when you look at comparables, I think it's always important that you bear in mind that the comparables either should be or need to be adjusted for the difference between what a landlord is asking of a new tenant who might be moving in for the first time and what the landlord is charging his existing tenants. And very often, not always, but very often, existing tenants are paying less, sometimes significantly less, than what new tenants pay. So again, it goes into that weighing process. The fifth grouping is what is included in the rent. Does the rent include heat? Does it include utilities? If that's relevant to comparables, if you're comparing someplace else, but it's also relevant to just simply evaluating what the rent is. And one of the circumstances that sometimes just results in complaints and that you can deal with are there's no rent increase at all, but the landlord has just shifted, say, the electric bill from a bill that the landlord was paying to now a bill that the tenant's going to pay. And the rent stays the same. Or maybe the rent even comes lower, but not nearly as much lower as the new cost that the tenant's going to absorb on the electric bill. Well, that's a ground for a complaint. You're going to have to decide whether it's justified or not. But it certainly could be, and it's within your jurisdiction if you so choose to treat. That would be a case where there was actually a rent reduction, but yet the net effect of the reduction was to increase the rental charge. And the ordinance and the statute speak about rental charges. And finally, the last item is a category that I would call tenant income and moving alternatives. The tenant, for example, you will certainly get tenants complaining who basically say, I can't afford to pay the rent increase. I'm on Social Security. I have no new source of money. I can't pay it. And it's more than consumer price index has gone up. That is a factor. It's a factor that there's nothing else out there that the tenant could move to, that they would be able to afford either. But you also cannot say to a landlord, you're expected to subsidize your tenant's rent. And that's why, for example, landlord costs are an important factor, particularly if they're legitimately disclosed. And so it may make a difference. One of the things I learned in Hartford was that in dealing with the very common complaint that the tenant couldn't afford the rent, that it might make a difference as to how big the building is. A 20-unit building with one complaining tenant, it may not be that burdensome if the commission were to decide that a rent increase for an existing tenant had to be held down. On the other hand, if it's a two-family house where what the tenant is paying is half of the landlord's revenue, the commission might be less sympathetic, might give less weight to the tenant's individual financial circumstances, because it's going to have a bigger impact on the landlord's capacity. So again, these are things that you weigh. So that was the third thing I wanted to talk about. And the last thing I want to say as a general category is, how does the commission decide a case? And you are in a quasi-judicial situation, which means people in the audience, for example, these are all public meetings. All parts of it are public. That's to say, not only the taking of testimony, but also your own decision-making. This is not a court where the judges can go into chambers and decide cases on their own. You're going to decide your cases in front of everybody. There needs to be that separation between the people who are testifying and the audience. The audience, someone can be called as a witness by either party, or even could be called as a witness by the commission, but they don't get to testify just because they want to volunteer. Somebody's got to, one side or the other, or the commission needs to call them. And typically what I think will happen is you're going to have some information that you may have obtained through municipal staff. For example, if the code agency has gone out and looked at the apartment, you're going to have information as to whether they found violations or not, whether there's an order outstanding or not. I mean, you'll have somebody who's actually seen the apartment who's completely neutral on this. They'll take testimony from each side. Typically, the tenant would go first because they're the complainant. Typically, you would swear in any witness. The presiding officer has the authority to swear people in that they're going to tell the truth. And typically, the tenant would speak first and explain why they feel this is unfair. They might call a witness. They might want to bring in somebody who's seen the apartment. You can ask them questions. The other side can ask them questions. And typically, I'd say when the tenant presents a case first, then the landlord can present a counter case. Landlord can testify, can be sworn in. People can have a lawyer, but don't have to. And my experience is most Fair Rent Commission cases, there are no lawyers. Most rare for tenants to have a lawyer, more common for landlords to have a lawyer, but probably at least half the cases, nobody has a lawyer. And they may and in those kind of cases, they're often very unfamiliar with any sort of a process. You're not running a court. It's much less informal than a court would be. The rule that you don't follow the court rules of evidence, you can pretty much take in whatever you want. But you need to do it sort of in an orderly fashion. And then when you're done, sometimes commission wants to, they want it back after they've heard the tenant talks, the landlord talks, and then now that's given you some more questions you want to ask the tenant. You may ask the tenant to come back up again and answer some more questions. At some point, the commission decides it's done with taking in new information, and you close the hearing. And once you close the hearing, you're then going to need to make a decision on the case. And so it'll be sort of the discussion part of the meeting as a whole. In the discussion part, only people who are there by invitation with you, I mean, people who are physically in the room or on Zoom, and sometimes you may want to have a staff person be included in the conversation. But ultimately, you're going to decide and take a vote. Somebody will have to make a motion as to what the result's going to be. So commonly, sometimes the commission member will make a motion up front and then you discuss. Sometimes the commission may discuss first and then ultimately someone makes a motion. My advice to the commissions is to do the decision portion of the meeting the same day that you're doing the hearing. And there are two reasons for it. One is, well, there are three reasons at least. One is you're done with it and everybody knows that day what the rent's going to be, who's won, who's lost. The second reason is that you're going to forget. And if you come back a month later, you're not going to remember all the details of what you heard the month before. You do it right away, it's fresh in your mind. And the third thing is you might not have the same people. And that creates a problem because you've got somebody who is present for the hearing may be absent a month later at the next meeting. Now, what are you going to do? Well, you could say, well, that person does this, that you're going to have fewer people vote. The whole commission's not going to vote. But you may at some point run into a quorum issue if you do that. Or you can say, you could say the commission member who wasn't there must play back the tape of the hearing that they were not at, because they're going to be voting at this second meeting. And that's probably acceptable, but that's really inconvenient. The convenient thing is you do it all at the same time. And if you had one hearing, you'd be one hearing followed by one discussion and vote. If you had two hearings, you could either do the discussion after each hearing, or you take your testimony in two separate hearings, and then after the two are done, one by one, you take each of the discussions and discuss and then vote. So that's basically what's, in my experience at least, is what goes on. It's sort of the major things that you have to deal with. And I think then I'm just going to stop and let you sort of control the direction from here. I told Lori that I looked for the first time this afternoon at your handbook. I think there's some things in the handbook that I disagree with, and I would hope you would consider modifying it. I sent over to her a little before this meeting tonight. I did sort of a red line markup, just so you could have something from me in writing.
Tracy, I
Again,
did,
not
print it
everybody.
out for
I'm sorry?
Everybody has a copy who's in the room.
Oh, okay.
So
And
if you
again,
want to go over it.
sure, I'd be happy to do that. But again, I want to say, not everybody agrees with me, and you're going to get my perspective and why I think certain things should be done certain ways. You know, I'm not your boss in any way on this, and so you take what I say for what you feel is helpful to you. If you want, I can. Do you want me to run through those, or do you want me to leave it for you to ask questions on those, or you tell me how you want to proceed from here?
I have a couple of questions about what you just discussed, and then maybe we can go to the handbook.
Okay, sure.
All right. So one question I had, if it turns out that the tenant really can't afford it, the increase, and they really are a candidate for subsidized housing, does any of that discussion come up as part of the meeting? Because that seems to me a separate avenue for that tenant to take versus through the complaint process.
Yeah, let me say something about the conciliation process, because it's really, really important. When the legislation was being talked about last year, people really didn't understand this aspect of it, because they imagined every time a tenant came in, there was going to be a hearing at the Fair Rent Commission. And that simply isn't true. I think a good half, maybe more than half, settle before there's a hearing. And that's because landlords and tenants find it very difficult to talk to each other when they find themselves in a disagreeing position. I mean, there's some places where the landlords and tenants are good at it, but I would say generally they're bad at it. So that the commission, and particularly whoever's handling the commission for the municipality, is really in a pivotal role to help the parties work this out themselves. So let's take the case where you have a tenant who really can't afford a rent anywhere. And if they may be in a better situation staying than leaving, but if they leave, it's just going to compound a bad situation, because they're going to be behind in the rent almost immediately, and they're going to have to pay for a move. And I mean, and they're going to they could end up in a shelter, they could end up doubling up with somebody in the family, and you don't know what's going to happen. That's a place where the person who is functioning on behalf of the municipality can help explore, is there an alternative that either finds a rent subsidy for this tenant, or finds a place that might be subsidized they could move to, or finds a program that deals with people who are in exactly this situation. Because the tenants often, or the landlords for that matter, often have no knowledge of what might be out there in a way that anybody can be helped. And the state does have programs, and as a result of the pandemic, they had money during the pandemic, and it generated a number of new programs, some of which are closed at this point, excuse me, but some of which have continued in a different form. They've kind of mutated into a different form. So for example, the Department of Housing has a short-term program now. During the pandemic, they had a program that was designed to pay off large arrearages that people had accrued. Now they have a program that's designed to either help pay smaller arrearages for people who are behind in the rent, or to help provide carryover funding for them to move to somewhere else. Again, they have to have somewhere else to move for that to work. So those are possibilities. If nothing can be worked out, and if it goes to a hearing, then the commission's going to have to weigh whether there is a partial remedy that it could impose. I mean, and sometimes what you see is that a commission decision will be exactly the decision that the staff person thinks should have been reached by the parties through negotiation, but one or both parties wouldn't agree to it. I mean, maybe it was a partial increase in the rent, but not a full increase. And the tenant says, I'm not paying a penny more. And the landlord says, I'm not taking a penny less. And the staff person sort of tries to gently prod people to look at some number in between, and they both say no. So it's going to go to a hearing. And the commission, hearing them out, says, essentially, some number in the middle seems what would be the right solution for this case. And they move it. It's a motion, you vote, if it passes by a majority vote, that's the decision. It's binding and enforceable as a decision. So in effect, what you've done in that particular kind of case is you've resolved an issue that the parties should have worked out between themselves, and arguably could have, but didn't. For whatever reason, the dynamic did not permit them to reach that. That's not an unusual disposition. But you also have cases where one party is really right and the other party is really wrong, and it could go either direction. And there you may end up saying your decision becomes all one way or all the other. My experience in the Hartford Commission, there are two aspects of it that maybe you may find interesting. One is, even though the Hartford Commission had 9 people, it was 1/3 landlords, 1/3 tenants, 1/3 homeowners. And I would guess that like at least 85% of the decisions were unanimous. People's conscience, when I talk about the conscience of the community, turns out not to be that different, whether you're a landlord or a tenant. Now, that leaves 15% where there were split votes and majority wins. But it wasn't particularly common to have split votes. And when I actually counted this up at one point when I was there, and roughly 1/6 of the decisions were all for the landlord. That's to say, tenant loses, rent increase is fine. Another 1/6 were all for the tenants. That's to say, we're not allowing this rent increase at all. Landlord gets 0. The other 2/3 were kind of in between decisions, where the landlord would get all or most or a significant part of the increase, but it would either be phased in or there would be some condition that had to be met first. And it would be hard to answer the question, who won those 2/3 of the cases, who won, who lost? Because in the end, they both got something that they wanted, but they didn't necessarily get it right away. So that's been my experience. And I think, and that's something that sometimes the commission actually explores during the hearing. The tenant comes in and says, I can't pay a $75 rent increase. And the commission member says, well, what would you think about it? What do you think about a $30 rent increase? And the tenant might say, no way. Or the tenant might say, well, maybe I could manage that. That's not a concession. It's not an end of the case. It still has to be decided and balanced, but that might influence the commission when it's making its decision. And I think that's okay. That's legitimate. I don't remember if I don't think your ordinance has this. In our model ordinance, we have suggested that in the section that lists the 13 factors, the ordinance add a sentence that says nothing precludes the commission from considering any other factors that are relevant. And because in fact, commissions consider other factors all the time. I mean, the boundary is relevance. But sometimes commissions think, well, we're not allowed to, but there's nothing in the statute that prohibits it. It's just, it says if these are appropriate, if these are applicable, I think is the word they use, then they're supposed to be among the factors that you consider. But you'll have cases where some of the factors are not applicable. They don't fit the circumstances, or they don't really influence your decision one way or the other. Even
Rachel,
though
we
you might
do
hear
have that in
testimony.
ours. We do have that wording in ours. Nothing in this section shall preclude.
Right.
So we did add that.
Oh, okay, yeah, okay, well, that's
did.
good. I'm sorry. I
We
didn't-
did. Mhm.
I think it's good to have it, but it's not necessary.
Right. I have a couple of questions or comments when I can be recognized. I don't want to interrupt anybody, but.
You have more questions?
Oh. Fine with me.
All right, so Rafi, I'm Ned Fitzpatrick. I'm the borough attorney and also I'm
Ed?
sorry.
And just one quick question. This is more of a clarity on protocol. So what I thought I heard was the tenants and the landlord each make their case. Then the hearing is closed. And then there's a motion from one of the commission members about a solution, and then we vote on that, and then we discuss and vote on that solution. Is that the protocol? Did I get that right?
Yeah, I think that
Pretty
in general, I mean, there are numerous exceptions to everything. And a lot of things are a matter of judgment. But as a general proposition, I mean, my suggestion is tenant goes first, presents their case. Landlord goes second, because again, the tenant as the complainant would normally go first and lay out what it is they want and why they want it. And then landlord goes second. You may give each party a second turn, after they've heard what the other party had to say. But then ultimately, you close the hearing, you have a discussion. Either you begin the discussion with a motion and then discuss, or sometimes commissions will discuss first, and just to see where everybody is, and then they make the motion. You can do it either way, but ultimately you need a motion. You need something that can be voted on, because who's ever functioning as the secretary is going to have to write it down and ultimately convert it into a piece of paper that you can send to the parties and say, this is the decision of the commission. So you need to ultimately have a decision in writing that at least briefly states what the reasons are. I think the court cases have said you do not have to identify the reasons. You don't have to go point by point in a decision, but there needs to be something in the record, that's to say the testimony, that makes it rational that you could have come to the decision you come to. The general rule on it is it's very hard for someone to win an appeal from a Fair Rent Commission in court other than on a procedural ground, because the courts have said as long as the decision has some rational basis in the testimony that you heard, the court will defer to what the commission decided.
Right.
But if there are procedural defects, the commission could lose on appeal because they didn't follow reasonable rules, or maybe even their own rules for how they were going to do a hearing. Ned, does that match? Does that fit with your own perception?
Yeah, I mean, I think that a couple points. One, the hearing has to be fundamentally fair to both parties. You have to afford the parties the opportunity to present evidence to both oral and testimonial, and any type of demonstrative evidence or documents they want to present. Both sides, they want to present witnesses, they may. If the commission decides to bring in witnesses either by subpoena or in some other, the staff member or public health director comes without a subpoena, that can be presented, and each side gets a chance to cross-examine that witness or any other witnesses. And then the decision makes it after the close the evidence, the commission makes a decision based on the evidence, and that decision will almost always be upheld, provided there's some basis in it in the decision that relates to the testimony that was taken down below at the hearing. That's the way I read the standard. And Rafi, one of my questions was, so I didn't read where the UAPA applies here, but it sounds to me, it seems like it doesn't. But it seems like the principles of meaning, really, you can almost the hearing panel can the quasi judicial panel can allow in any evidence they deem is appropriate, even hearsay evidence.
Mhm.
It can be admitted, I suppose, for the weight of what it's all worth. But in matters like this, there's got to be hearsay evidence all over the place, because you're bringing in histories of rents, you're bringing in maybe comparable apartment rents in the area. You might be bringing in not firsthand testimony. So, hearsay evidence to me is going to be replete in these hearings. And so I want the commission to be comfortable that what's commonly known as to us lawyers is hearsay evidence not admissible in a court, since this is not a court proceeding, would be admissible here, depending on if the commission thinks it's relevant, is it appropriate for this case. The second point I wanted to ask and make was that, and I think it was well done by you, Rafi, is that the 13 factors, and among other, and by the way, in addition to maybe others, that no particular weight. In other words, the 13 factors don't have to be weighed evenly. So, 7.77 times 13 is each factor doesn't get 7.7% or whatever that number is. Some of those factors may not be relevant to each decision. And I think that's important for the commission to know, that they don't have to apply all the factors to that decision, and they don't all have to apply evenly. It might be only 2 or 3 factors that apply, as Rafi, you pointedly made that obvious. And I think that's important for the commission to know, non-lawyers to understand that is part of the process. And that's what's contemplated, the way I read the statute anyway. Now, the other part of the comment I want to make is, I agree very much with your recommendation that the date of the hearing should be also the date of the decision. In other quasi-judicial administrative hearing processes, we find that the commission and the public is much better served when a decision is made the same night that the evidence is received, to the extent time allows, of course. But it instills, first of all, that every decision is made in public on the record, which everything should be. But it instills confidence in the public that there's no behind the scenes discussion and, we're going to continue it a month and, that something might happen in that period of time. No, the discussion is made in public in front of the landlord, the tenant, other witnesses if they happen to be there, but it's upfront. So I think that there's transparency with regard to the process, and I think that's important because it instills confidence in the process for everybody. And I like your comments with regard to that aspect of deciding, hearing the matter, listening to the evidence, closing the testimony, having discussion on the evidence, making a decision, and doing it that evening in front of the complainant and the complainant and by the way, I agree with you. The tenant, normally there's the complainant, obviously, and has the burden to go forward, and the initial burden. But I think that's the proper process. I think it's for the right reasons, and I think this commission will take heed of your advice.
Okay, thank you.
I have a couple questions. In your experience, are you seeing a lot of people going to court after the commission has rendered a decision?
No, appeals are very unusual. There may be some changing in that dynamic. There's been a major case coming out of Hamden where that has had sort of a whole different tone, because there was active organizing by tenant groups in a large complex against a very well-funded institutional landlord that has the capacity to fight hard. And that case is I believe is on appeal in the Superior Court in New Haven. I'm not quite sure what the status is. That's unusual, but maybe is, I mean, we're in sort of contentious times. And maybe that it's possible there could be more. But as Ned pointed out, it's really, really hard to win an appeal, whether you're the landlord or the tenant taking the appeal. It's really hard to win the appeal unless you've got some procedural defect to hook onto. So you can argue that this whole decision is bad because they made a mistake in the process. But if your argument is, I don't like the decision and they should have come to a different conclusion, that's a tough sell unless the commission really had no reason at all for making the decision that they made. So the answer to your question is it's pretty unusual.
Okay.
I can't say it never happens because it has happened. In the 50, I've tried to find every case that went to the Supreme Court in the last 50 years, and I found about a dozen of them. And which says it doesn't. Now, of course, it can be in the older cases. It's a little harder to find Superior Court cases than it is these days. But my sense it's unusual.
So
We'll see if it changes. I mean, with more towns doing this, with more inexperienced commissions, maybe greater risk of error. Who knows? Okay, but simple answer, probably not.
So in your experience, have the landlords appealed more or have the tenants appealed more?
Typically, it's the landlord who's going to appeal.
Okay.
In New Haven, there's a procedural appeal out of New Haven, which apparently somehow got settled, but came from the fact that the state statute does not say how many days you have to appeal.
Right.
So we've advised towns to put an appeal time into their ordinance. Typically, it might be 30 days. New Haven's ordinance happened to say 10 days. But what happened in New Haven was they made a decision at the meeting, and it was 10 days to appeal, but they didn't mail out the decision in writing for another week or so. And the appeal was taken during that difference, and whether you counted the date of the decision at the actual meeting as being the date from which you appeal, or you counted the issuance of the written decision, which didn't happen until a week later, made a difference as to whether the tenant could take an appeal or not. And when we were drafting the model ordinance, we basically opted for recommending that the appeal should be measured for when the written decision is issued, because otherwise neither party, landlord nor tenant, really knows what the decision is, even though they might have been in the room and heard the motion. But that's a case where that could be won or lost on appeal, because that's a legal issue that the judge could say either this appeal was taken in time or it was taken too late. So that was sort of unique because it was a very specific issue on what the ordinance meant in its wording.
So my last question is, in your experience, you said something interesting that, the landlord wants X, the tenant wants to pay Y. And if the commission has ruled in favor of the landlord, he's met all his obligations. The life cycle of the rental agreement, have you found that these landlords have had trouble collecting the new rent? Or does
I guess if the tenant loses, then the tenant's going to have to the rent increase is essentially imposed. It now becomes the rent increase because the commission has endorsed it. If the tenant doesn't pay it, they're going to be subject to eviction for non-payment of rent. And that is not retaliatory.
Right, but so I understand that, but there is a passive aggressive retaliation on the part of tenants that they just stop paying the new rent. Has that been your experience?
I don't want to overstate my experience on this. So I will tell you my sense rather than my experience. My sense is that for tenants who want to stay, they may grumble, but they pay the new rent. If they really can't afford it, I mean, if this is a case where the tenant genuinely cannot afford the new rent, then they're probably going to move. And in that interim period, between the time they've lost and the time they're going to move, you may have a situation where they stop paying the rent. In part because it's hard to move. If this is one of the dilemmas, and from a landlord's entitled to the rent, even if the tenant's going to move. But the more the tenant pays to the landlord, the less capable they are of finding another place. And so that's especially in the low income community. And so that's always, I mean, that's always been an issue and a dilemma as to how you deal with that. My sense is that most of the time, the tenant is going to accept the decision. They made the choice. They didn't just withhold the rent. They made the choice to complain. So the odds are they're going to live with the decision, but not always. And sometimes, I mean, certainly it's true that sometimes tenants grossly misunderstand what a commission is likely to do. That they're mad about the increase, so they jump to the conclusion that of course they're going to win. You can't. I mean, that's not smart. I mean, that's not accurate, because you really don't know. And tenants are often not in a good position to gauge the likelihood. I mean, what I can say is the larger the rent increase, the greater the chance the tenant's going to win. When I was on the commission, tenants won some cases when there was no rent increase at all, or a nominal rent increase because of the condition of the premises. But as a general rule, is the tenant going to win a complaint against a $15 rent increase when there's nothing wrong with the property? I mean, the odds, it would be pretty unusual that a tenant was going to win that. And if you were advising the tenant, you would probably say, look, it's not even worth going to the commission, you're going to lose. When does it become large enough that it starts to become, as you weigh the factors, a factor that starts weighing more and more heavily in the commission's decision? It's hard to know. But I mean, so there's some predictive factors, but I think tenants who intend to leave anyway, or determined they're going to, then they're more likely to leave and not to file a complaint. That'd be my experience. But, you know, there isn't any tracking on this. So there's no way to know. I mean, you're not going to, as a commission, even if as a lawyer, if I were representing the tenant, I might well not know what happened after the case was decided unless the tenant comes back. And you're not going to know probably unless somebody comes back and tells you what happened afterwards. And one of the concerns, and this has to do with the retaliation piece, is that every once in a while we've become aware of a situation where a tenant won at the commission. The landlord's response was to bring an eviction. And the tenant, who had no lawyer, never came back. I mean, I worked for a legal aid program, never came back to the legal aid program to tell them that they were facing an eviction. And even though they wanted to stay, in the end, they moved. And nobody even told the judge that there had been a Fair Rent Commission case. So the judge had no idea. And typically it was a lapse of time eviction, which would be plainly retaliatory. But somebody's got to raise the defense. And so we do know that sometimes that happens. I've suggested to some commissions, I don't think anybody's put this into an ordinance. I suggested it in Meriden. I'll be interested to see if they put it into the ordinance, because somebody asked me. But if there's retaliation, let me start the sentence over. The town, the municipality, and the tenant have separate, distinct interests in there being no retaliation against the tenant. The tenant obviously doesn't want retaliation because they're going to get retaliated against, and that's not going to be good. But the municipality has an interest in making sure that its decisions, whatever they are enforced and followed. And if a situation arises where the commission doesn't do what it needs to do to protect people who file complaints with the commission, ultimately people will stop filing complaints because they will be afraid of retaliation. And so, for example, I think tenants should understand that if they feel they've won a case at the commission, but they feel they're being retaliated against, they need to come back and tell the commission. If the commission finds out, the commission can issue a cease and desist order against the landlord, but under the statute, there must be a hearing. You cannot issue a cease and desist order without a hearing, which means the landlord has the opportunity to come in and say, no, 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 there's no retaliation here. But if they do issue that, it's my advice to the commission, take that piece of paper. If you know that there was an eviction filed that is apparently retaliatory, you can order the landlord to withdraw the eviction. But I would say, take that piece of paper, somebody take it to the courthouse and tell them, put this in the eviction file. Because you want the court to know. Why would you do that? You're not a party to the eviction. You can't tell the court what to do, but you have an interest as a municipality that your cease and desist orders be complied with and people not get around them. And how do you make sure the judge knows? You can rely on the tenant. Tenant may or may not be reliable, but you can do it yourself. I don't think that's in anybody's ordinance stuff. That's just me.
So I think you answered my next question. Is there any place that you have seen that has a follow through to see that the tenant is paying? Let's just say that the landlord has won and he's got a $10 rent increase. Are there any municipalities now that say, hey, you know, the tenant is complying with our order?
I don't think anybody, I'm not aware of any town doing any follow-up unless one party or the other comes back to the commission. So if it were a tenant who, for example, if the landlord was refusing to accept the decision and was insisting on the rent increase, even though the tenant won, the tenant's got to come back to the commission and tell you, because you're not going to know otherwise. And one way this happens, again, we've made the recommendation in the model ordinance that there be a default duration of your decision. In other words, how long does your decision last? Because there have been landlords who've said, okay, well, you decided the rent should be X. Well, that'll be for this month. Next month, we're raising the rent again. After you just rejected the rent increase. And they say, well, we're not violating your order because we'll accept your order for that month, but now it's August. And so we want a higher rent in August. And so most commissions have put a duration on their decisions. And I would say the most common duration is 12 months. And that's because the most common length of a lease is 12 months. But I think there's sometimes the commission might say the order is going to be in effect for 6 months. But I think it's good for there to be something, whether it's, I don't remember if it's in your ordinance or not, but something that says in the absence of the commission setting a different duration, the commission could always set a different duration, doesn't bind the commission. But in the absence of that, all our decisions are so long. And the significance of that is that during that duration, the decision has to be followed, whether it's a single dollar amount you've set for the whole period, or whether there was a phase in and you said after certain events, certain things would happen. But beyond that, it becomes a new case. So for example, if it's a 1 year order, you've decided what the rent is for 1 year. You get to month 13 and the landlord now seeks to raises the rent again. If the tenant wants to object, they're gonna have to file a new complaint because your decision is expired. But if after month 6, you've done a 12-month decision and the landlord says, now I'm raising the rent, the answer is no. If the landlord wants to raise the rent during that 12-month period, it's going to be the landlord who's going to have to come back to the commission and ask for them to modify, for the commission to modify the decision. It's not that you can't modify it, you could, but if somebody's got to ask you to modify it. So there's some circumstances where the landlord might want to ask. There's some circumstances where the tenant might come in and say, your decision's not being followed. You need to tell him he has to comply. The point at which you issue a cease and desist order, which I think is quite unusual. There are not very many cease and desist orders issued by commissions. But at that point, then the commission really should pay attention to whether it's complied with or not. And that would be the one circumstance where I would say the commission ought to take some initiative and make sure that the order is complied with, because you've held a special hearing for the purpose of deciding whether to issue this order. And you want to make sure that it's being obeyed. It just might mean a staff person contacts the tenant and asks, is there any problem with compliance here? And it's not like, you don't have to do a big investigation or anything.
I have a question because we have a couple pieces of information in our binders here. One of them is the fair rent commissioners frequently asked questions. And it says here, can commissions accept complaints where a tenant has already signed a new lease? And in this paragraph, it says, yes, it's not unusual. And then in the draft of our draft over here, it says that the tenant has already signed a new lease. So it's directly in conflict with one.
Yes. As I said at the beginning, when I read the handbook, there were a couple things I was concerned about, and in the markup, you'll see you'll see that whole section I crossed out. The only thing that is explicit in the statute is the ordinance doesn't cover short-term rentals of 120 days or less. In practice, I think there are two other categories of things that you don't cover. And it's found its way into some ordinances, but in some it's just the practice. The first is things that are not covered by the Landlord-Tenant Act would not ordinarily be covered by the Fair Rent Commission, and that's partly because it uses the word tenant, which is defined in the landlord-tenant laws. So, for example, the nursing homes are not covered as places of residence that are subject to the landlord-tenant laws. If you're going to evict someone from a nursing home, you don't go through the court eviction process. I mean, there's certain other things. Transient occupancy is not covered. Hotel, transient occupancy in a hotel is not covered. There are a bunch of things like that. You're not going to get those cases. I mean, nobody brings those things to the Fair Rent Commission. But I think as a practical matter, they would not be covered. A university dormitory would not be covered because it's collateral to education. But student housing and ordinary apartments, that's certainly covered. There's nothing that says that a student who's going to school, in a nearby college, is excluded because they're students, and there'd be no exclusion for that. What you have in your draft that left me, I guess I'm more concerned about some of the things than others. But the one thing you said is that if the landlord has brought an eviction, the tenant can't file a complaint. That's, I believe, completely wrong. And you don't want it for your own reasons, because you don't want to have a race to the courthouse. I mean, you don't want a situation where the tenant, who doesn't even know there is such a thing as a Fair Rent Commission, tells the landlord that they don't want to pay the increase. They're not going to pay the increase. The landlord jumps in, serves a notice to quit, starts an eviction. The tenant ultimately finds out they could file a complaint. They file a complaint, there's now an eviction pending. Well, the eviction is going to go its own route. But you are entitled, the tenant is entitled to get a hearing from you on whether this is a rent that is essentially so harsh, so excessive as to be harsh and unconscionable. They're entitled to that decision, and at least as long as they're living there. And the court may find that the court may well put a halt to the eviction of its own initiative if someone tells it there's a pending case at the Fair Rent Commission. So the assumption that somehow the court takes precedence over the commission, I just think is completely wrong and invites retaliation. So that's one thing. You also say if the tenant's behind in the rent, you won't take a complaint. I think that's completely unacceptable, because you're dealing with rent increases. I mean, you're dealing with people who may bring a complaint because they don't have the money to pay the rent. And if they were ultimately to prevail, they might have been able to pay it. And the landlord may say to them, I'm raising the rent $100. If you don't want to give me the $100, don't give me the old rent. Just pack up and get moved out of here. I'm not going to keep you if you're not going to pay. So they don't. And then your handbook seems to say, well, if they file a complaint with the Fair Rent Commission, they can't, because they're behind in the rent, because the landlord told them, I'd rather you move. Those are the kind of things. Now, the trickier part is, what if they've signed a lease? That I think is a much more of a border. So those two things I think are open and shut. You really must take those complaints. Could you choose to make a rule on leases? That is harder. And the reason it's borderline is a lease is supposed to be an agreement. It's a meeting of the minds. When the tenant complains to you, the tenant is saying point blank, I don't agree to what it says in the lease. Now, you can say, well, too bad, you shouldn't have signed it. But our experience with renters is that there is so little understanding of what alternatives are and so much threat. If you don't sign the lease, then you're going to have to move because I am not bringing down the rent for you. And it's common. And in fact, both landlords and tenants often don't know the towns have fair rent commission, including towns that have had them for decades. I mean, we've seen that over and over again. So the problem with saying that signing a lease, especially signing it under threat of eviction, if you don't sign it, has bound the tenant not to file a complaint. I think factually that most of the time, the tenant will not have intentionally waived the right to complain. And for that reason, I think that the way the commission has to approach it is that they'll take the complaint. And might it be one of the factors that you weigh that's not on the list of 13, but is still a very relevant factor? Might be, did the tenant knowingly and understandingly agree to this rent increase, and now they're having, the buyer's remorse? I think it's a legitimate factor to consider, but I think if you consider it, you're going to discover that 80% of the time, the tenants thought they had no choice. And it's only after they signed that they learned that they had an alternative, which was to go to the commission.
Well, that was my thought as well, is that it's sometimes the signing can be in a way of protecting from retaliation because they don't want to leave right now. So they sign with the anticipation of filing a complaint, or I'm not sure what, if that's way. Does that make sense? Do you know what I'm asking?
Yeah, no, it makes sense. I can't say that there aren't tenants who've learned eviction law, who've learned landlord-tenant law and know it. But my experience is that they're not a lot of them in that situation. And landlords are more likely to know law, but there are an awful lot of landlords who don't know anything about eviction law either. I mean, I was involved once in a situation where at the legislature, where a landlord testified to something about how long it took to do an eviction. And I asked them, because it was way longer than an eviction takes, where'd you get that information? He said, my tenant told me. It's like, I mean, if I was the tenant, I wouldn't get my legal advice from the landlord. If I was the landlord, I wouldn't get my legal advice from the tenant. It's, anyway, so where I come down on that is that the commission should take the complaints, and that certain things arguably might be a factor that would influence ultimately how the commission makes its decision. But I would not do things that, things that oust you out of jurisdiction. You really don't want to accept those, I don't think. So for example, the court process could be a parallel process, but and there's a specific case, actually. There's a court decision that says the commission cannot issue orders against the court, but the commission can clearly issue orders against the landlord. The court can choose to enforce those orders if it wants to. Doesn't have to, but if it can if it wants to.
Okay, so generally speaking, because that was one of the concerns I had, is that we should accept complaints from whoever wants to make them. And then we go through the regular municipality kind of avenues, and then it comes to us if it comes to us.
Yeah,
but we accept all of the complaints and without any of these stipulations on there.
That's my opinion. It may also turn out that some of these complaints are going to settle. I mean, if we know that a lot of the complaints get worked out without ever getting to the commission, by in effect taking the complaint and then starting a conciliation process, you may end up solving the problem. And I mean, there's at least like a 50% chance you're going to solve the problem. There are some other things that can be tricky. if, for example, the commission cannot overrule, let's say somebody's on Section 8, this has come up as an issue. They're paying 30% of their income as rent. And there are people who've said, well, that means if you're on Section 8, you can't file a complaint. But that's not true. And that's because there's an element of truth to it. The commission cannot change the percentage formula that the tenant pays for rent. Right? If the tenant pays 30% under federal law, the tenant's obligation is 30%. It doesn't matter what you say. You're essentially preempted. But the tenant also cannot spend more than 10% of their own money above the 30%. In some circumstances, there's no cap on what they can pay out of their own pocket. The federal law does not regulate what the landlord charges. It regulates whether the tenant can live in the apartment and whether they're going to have to pay more than 30% of their income if they do. But it doesn't regulate what the landlord charges. The landlord can charge anything he wants. And one way some landlords get out of renting to people on Section 8 is they push the rent up to a point where it's going to be over Section 8 fair market rents. You have jurisdiction over the landlord setting of the rent, even though you don't have jurisdiction over the fact that the amount the tenant is going to have to actually pay is controlled by a federal formula that you have no right to change. And I think when people think of it and look at it that way, they realize that just because someone's on Section 8 doesn't mean they can't complain about a rent increase. And nor does it mean they can't complain about a rent increase that is unfair, not because of the amount of the rent, but because of the maintenance of the property. Because one of the things the commission can do is it can find a rent to be unacceptable, not because of its dollar amount per se, but because of the lack of maintenance of the property has essentially devalued the property. And that's the Section 8 issue. It does not preempt you on that. So my view is if there's any reason at all to believe that there's probably some jurisdiction, you should take the case and not be turning them down.
Thank you.
I asked a question real quick. So how would that be for our housing authority that has elderly and disabled and Section 8 people?
You're not going to be able to override a housing if a housing authority with a rent that has been set either by federal formula or by if it's a state elderly housing development, you're not going to be able to change the rent. If the complaint was solely about the amount of the rent, then I would say that's something you probably don't take. If the complaint is about the conditions and maintenance, I think you would take it.
Okay, thank you.
Raymond has his hand up, by the way. I don't think I'm authorized to call on people, but
No, that's great. I was waiting for you to call on me.
oh, okay. Well, Raymond, you're called on.
It's nice to meet you. My name is Raymond Caruso. So I heard that when you were on the commission in Hartford, you had 9 members.
We had 9 members.
Is that true? So was that evenly distributed between renters, homeowners, and tenants?
It was I don't know if I actually don't know if they still have the same ordinance, but at the time I was on it, it was 3, 3, and 3. It did not affect the attendance at any particular hearing. I mean, this is a problem with trying to do a balance. And I mean, you were sort of struggling with it with somebody's absent, you replace the tenant with the tenant, landlord with the landlord. That makes sense. But what if your commission is 2 landlords, 2 tenants, 1 homeowner, both the tenants are absent, but the alternates are 1 landlord and 1 tenant.
And that's why I brought that up, because
Well,
our commission is that it's 2 landlords, we have 2 tenants, and we have 1 homeowner, which is Gene. We have 2 alternates, which is myself, and I'm a homeowner. So, and Jan, who's a renter, and he's a tenant. The more I sit in this group, the more I think our group should be expanded. And there should be another homeowner. And I'm not just saying it for myself, because I'm happy just to be involved. And I'm not a voting member because I'm an alternate, but I'm starting to feel that we should have another homeowner on here. So it should be 2, 2, and 2, or 3, 3, and 3 if we could even get that many people. I don't know, but I'm thinking that there should be an expansion a little bit, and I just what your feeling was on that, because I'm
Okay.
starting to like that to myself.
Well, first of all, I think you should always have an odd number of members so that you don't set, so it could be.
That's why I'd said
Well,
3,
it could
3,
be
3.
1, 3. You could have 5 members. It'd be 1, 1, and 3, for example, rather than 2, 2, and 1. When we were writing our model ordinance, which turned out to be me and Attorney Sarah White, pretty much, we struggled with this because we couldn't quite decide what we thought was the best way to do it. So we ended up recommending some sort of equality to, 3 categories, basically, with an uneven number. I would be okay with no restrictions at all, or with all homeowners, or 1 landlord, 1 tenant, the rest homeowners. Because I think as a practical matter, you don't want to cancel hearings because of absences that keep you from maintaining the balance. So you want the ordinance to be written as what the membership distribution of the commission is, but not what the hearing distribution is for the people who are sitting at any given hearing. You can try and use your alternates to keep that balance equal, but I don't think it's a good idea for you to end up having to cancel a hearing because, the 2 tenant members, neither of them can come, and you don't have 2 tenant alternates. So I would read, and I think I read your ordinance as saying that your balance is required for the membership on the commission, but is not actually required, although it might be recommended or desirable for any individual hearing. And I think that's okay.
Right.
I think it's okay to have a balance that weighs more towards homeowners and less towards landlords and tenants. In my experience, and this is one of the reasons I told you that our decisions in Hartford were almost all unanimous, is that although people bring different perspectives from a landlord and a tenant perspective, there tends to be a sense of fairness that's not all that different. And tenants recognize when a tenant seems to be unreasonable, and landlords recognize when a landlord doesn't seem to really be doing his job right and is not being fair. And so that there's often a lot of common ground, and so it doesn't make that much difference. On the other hand, I suppose for some purposes, it looks bad if it looks like it's an all landlord board. If you said 5 members with no restrictions at all, you could have a mayor who appoints 5 landlords, and then tenants feel that they're being cheated. So, there are some benefits to the credibility of the commission to have a balance. I don't think there's any magic. We debated whether to recommend 5 or 7 as a commission size. I think the smallest commissions are 3 and the largest are 9. So it's 3, 5, 7, or 9. I think I think there are only a couple that are 3. I think there's a little tendency to go on the larger side, but then it becomes hard for some towns to find members. You're gonna have 7 members, that means you got to find 7 people. And so I think there's some towns that have shied away from 7 because they think 5 is going to be easier to get, especially because they got to get a couple of alternates. So 7 actually, might mean 10, and 5 might mean 7 or 8. So I don't have a good answer for you on that. It's the ordinance. You sort of start with whatever the ordinance says, and then I think you have to apply your experience. And if you feel that it's not working, then somebody should think about contacting, talking to the town council about changing the numbers. Bridgeport is an example of the worst possible situation. Okay, because Bridgeport had, for 20 years, had one of the most active fair rent commissions in the state. And then the leadership of the town changed. They ended up, they actually had a full-time staff person there. They had a lot of complaints. They laid off the staff person. The mayor stopped reappointing anybody when somebody's term expired. And, after 4 or 5 years, you no longer had a functioning commission. You had an ordinance, but no commission. And that went on for about 20 years. And they finally realized 2 years ago that they were expected to produce an actual commission because people were starting to try to file complaints, and they were being told that they don't have a commission, even though they had an ordinance. They decided to do a 3-person commission because in Bridgeport, they didn't think they could get 5 people. I think they're now reconsidering that because a 3-person commission is so small that what happens when 2 people can't make the meeting? I mean, it's like you have no flexibility to deal with the day-to-day problems of a commission, of a real commission. So I don't know. I think 5 or 7 are the best numbers. I think either one's okay. I think 9 is a lot. And I think it's going to be what each town feels comfortable with. I'd like to think that everybody's available. I mean, one of the questions is how you deal with alternates. And I've had a different experience with a different commission in Hartford that I don't know if it can be transferred over to the Fair Rent Commission or not. And I don't know if it would be considered allowable. And I can tell you what it is, but I don't know that I can recommend it to you. I used to be on the Historic Preservation Commission in Hartford, which is a 5-member commission with 2 alternates. And the way we functioned was all 7 were encouraged to show up at every meeting of the commission. This was regulating people who'd applied for building permits in historic districts and they needed to get approval from the Historic Preservation Commission. And all 7 of us would participate in the hearing, could ask questions of witnesses, in the discussion, but if there was more than 5 people there, the 2 alternates couldn't vote. And the result was that the alternates came to nearly all the meetings. And if we ever needed an alternate, we always had one because somebody was there. One of the regular members couldn't come, they would just designate as an alternate as a member. I don't know that our allowing the alternates to participate that way was legal. Nobody ever challenged it. I don't know. It really worked. I have to say it worked because the members got the benefit of 2 extra people throwing their opinions in. And sometimes those 2 people's opinions were very valuable. They were very helpful in analyzing the case or deciding which way we were going to go, even though they couldn't vote. But I don't know what the law is on that. I'd be interested if I don't know, I thought Ned was still here, but I think he left. You might ask your town attorney on that. I think the answer might be no, you can't do that.
Right, yeah, I believe that's what we do with our other commissions here now.
For all the other commissions.
You do that. Well, then maybe you can. If you do that, then maybe you can do it with this commission. You can't have alternates voting unless there's a slot available for them to be a voter.
That's right.
But it also that vests the alternates in being involved in the commission. Otherwise, what happens is the alternate doesn't come unless you call them and say you're going to be short. That means you have to know in advance. It's like you have to take attendance before people go to the meeting. And the alternate doesn't get a feel of how the commission is deciding similar cases. I mean, you'd like to think that similar cases will get handled in a fairly similar way. I mean, even though every case is individual, you're going to see patterns of what is, as you get more cases, you'll sort of get a sense as to how people come down. But if people aren't at all the meetings, they don't know what happens at the meetings they don't go to. And so they're coming in cold, and better to come in warm than cold, seems to me.
Yeah. So
thank you.
You're welcome. I mean, if I can be I'm a big fan of fair rent commissions, if you haven't been able to figure that out from what I've said to you. And I want them to work. And I think they're really valuable. From a tenant's point of view, if you're in a town without a fair rent commission, there is no place you can go to dispute a rent increase, because there's no one who has the authority. If you're elderly or disabled and live in a building with more than 5 or more units, in theory, you could actually go to court if you don't have a fair rent commission in your town. Nobody does. There've been like 5 cases in court in 50 years, because you'd have to have a lawyer. I mean, it's like people who are complaining about rent increases usually don't have the money to do something that's not free. So, fair rent commission is free, so it's easy to do. But that's part of what makes it so important, is that from a tenant perspective, you don't have any way to get to raise the issue other than by withholding your rent. And if you withhold your rent, you're going to end up getting evicted, and it's going to be painful. And it's not in the landlord's interest. Landlord doesn't want to have to evict people either. I mean, that's expensive. So having a place where you've got at least a 50-50 chance of settling the case without even a hearing, where it doesn't cost anybody anything to go to the hearing, to have a hearing. I mean, there may be some, indirect cost to the town, but from the point of view of the participants, there's not. To me, it's a win-win for landlords as well as tenants. And it does level the playing field, and it keeps these things from being decided in evictions, where you're rolling the dice that you're going to be able to stay in your home, basically.
Thank you. Are there other parts of the changes you made to the handbook you'd like to review with us?
Let me just look at my notes and see if there's anything that I cared. The thing I most cared about was keeping people from filing a complaint. Wait, let me, where did I put my notes here? Let me look at this. I will try and tell you. Well, you'll see in some places I suggested some rewordings.
Yeah.
Because if a tenant, the primary if a tenant's not paying the rent, they're not going to have a defense to an eviction, and that's where that issue is going to get resolved. Whether the tenant is or is not paying is not a reason for the commission to be dropping a case. Let me just put it that way. I'm looking at what happens after. What is the remedy for a proven claim of retaliation? I suggested a sentence that I just thought would be helpful to you. Okay. I think
I
I
apologize.
think something that I feel strongly about. I mentioned to you in talking about in the section on what am I looking at here? I mentioned that you should beware of the difference between rents for existing occupants and rents for asking rents. That's also true. So I've been asked the question, for example, if the rent increase is below the Section 8 fair market rent, does that mean the landlord is always wins? And the answer is no, because comparables are one of 13 factors. And that may give you a sense for what comparables are, but also those are asking rents. Those are not necessarily occupant rents. And so it's a factor to be considered, but it may or may not be decisive.
Can I ask a question? I think I heard you say that if a tenant is not paying rent, they can still come to the commission?
Yeah. They can be evicted for not paying rent. From the commission's point of view, if you are paying the old rent, I mean, some landlords say, I've raised the rent. It's a language issue almost. Technically, if a landlord wants the higher rent coming up, lease expires the end of December, landlord wants a rent increase for January. The landlord technically does not, quote, raise the rent, because all it is a proposal. I mean, tenants all the time say, my landlord raised my rent. And I say, no, you have to agree to the rent increase. There's no rent unless you have an agreement on what the amount of the rent's going to be. But it's perceived of as a fact, it's not like a proposal and then a counter proposal and you can negotiate. If the tenant pays the old rent while this case for you
Oh,
is
okay.
pending,
Okay, good.
then they're protected from a non-payment eviction because they're paying the old rent. If the
All right.
tenant pays nothing, they are not protected. But the landlord's remedy is not that the complaint is thrown out by the commission. The remedy is they're going to bring an eviction for non-payment against the tenant. And that's not retaliatory in the tenant's filing a complaint. The tenant wants to have a retaliation defense to the eviction. They're going to have to say, I was paying the old rent. Therefore, this eviction is because I filed a complaint with the Fair Rent Commission disputing the increase.
So
That
they're in
then
good,
is an eviction defense, but not,
they're in good,
I stopped
they're in
paying.
good, they're in good standing if they're paying the old rent.
If they're paying the old, and the legal reason for that, I mean, we've suggested that you put that in the ordinance, and I think your ordinance has it, but there's a logic behind it. It's that if you don't have an agreement on the rent, then you don't have an obligation under a lease. You're in this in-between situation. And so until there's an agreement, it makes sense that you keep paying the old rent.
Yeah, that makes sense.
But,
Yes.
but the consequence of not doing that should not be that the Fair Rent Commission throws you out. It should be, but you're giving the landlord the capacity to throw you out through the eviction process. So that's the reason. So yes, even if they're not paying, you should hear the case. But they're not going to be able to block the landlord. And now the landlord may choose to wait. So I mean, landlords for their own reasons may decide that they're going to wait and see what happens at the commission and not start an eviction. They may not want to pay a lawyer to start an eviction for them. So it doesn't even automatically follow that the landlord's trying to evict. But my experience is most landlords would if they knew that the money wasn't going to come in, they would stop waiting.
Good. Thank you.
I like your logic that, you know, we shouldn't be giving away any of the power that we have because that's the reason that we're here. So we shouldn't forego any sort of accepting of a case because of anything like that. So I like that logic because we want to maintain our authority within, you know, our decision making. So that makes sense to me.
That's my recommendation to you. Yes.
Thank you.
Any other questions?
I have one right here. So if the the landlord won't accept the last agreed upon rent, that's when they would pay to us in our escrow account?
It's really, the escrow account is up to you. The only circumstance, by and large, commissions don't like escrow accounts because it means somebody's got to keep track of the money. So to my knowledge, in my 4 years on the Hartford Fair Rent Commission, I don't think we ever had a rent that was escrowed. It was left to the landlord and tenant to deal with it. But the statute actually says that if the commission orders what's essentially a zero rent, then it has to be escrowed. Now that it's the one place where the statute seems to leave no real wiggle room for the commission. So our interpretation has been that unless you order zero rent, it doesn't have to go, nothing has to go into escrow. If the landlord doesn't want to take the money, there's nothing that says the landlord can't ask you to have the tenant pay into an escrow account. So I think you can do it. I think if you want to do it, you can do it. You can do it at the landlord's request. You can do it at the tenant's request. But in the absence of a request, I would not recommend that you require it of anybody because you're just gonna find it annoyingly burdensome to have to deal with the money. And if the case goes on for more than a month, so that you get in a situation where you're looking for repeat payments, and Fair Rent Commissions don't like to have to bug the tenant. You know, what if the tenant doesn't send you the next month's rent? Do you write them a letter? Do you threaten them? I mean, what do you do? It's easier to let the landlord worry about that. So that's been my experience. But the answer to your question is yes. If somebody wants the rent paid into into the commission, and the commission's willing to accept it, the answer is yes, you could agree to do that.
Any other questions?
Yeah, I have one other one.
Yeah.
When I get a complaint in on the form, and I'm gonna probably mediate first, do I send that right out to the commission so they're aware, or do I wait until we see if we need to come before the commission?
I don't know the answer to that, and I don't know what commissions do. I think either is probably okay. I mean, what you want to do immediately when you get a complaint is you want to make sure you want it to be clear to the tenant that you've accepted the complaint. I mean, if they do it by mail rather than in person, you want to send them something. And I think you want to notify the landlord right away.
Okay.
So I think that you do right away. When you notify the commission members, it's really, I think it's a judgment call. I think the way we wrote it in the model ordinance, and I think is probably the better practice, is that you plan a hearing date from the beginning, even though you can project that a lot of these won't require an actual hearing. But there tends to be impatience on the part of both parties. I mean, the landlord certainly do not want this to be dragged out over time, because especially if the tenant is paying the old rent and they want to get the new rent, I mean, they want to get the hearing done and over with so they know what's going on. And the tenant doesn't like being in limbo either. So, and you don't know if how quickly the case is going to settle. So for example, you can target something. If you're doing monthly meetings, for example, you can sort of know right off the bat what month's meeting this is going to go on to. And you plan it for that meeting with the understanding that if the case gets worked out in advance, you'll take it off the agenda. And so I think it's, I don't have an opinion on whether you should send these to the commissioners right away or not. That's,
So
I don't
that's
know.
something to discuss. Yep,
Well,
okay.
I think that prior to we won't think we should probably wait to gather our information for the hearing itself. Does that make sense?
I'm sorry, say that again?
We should wait to gather information until there's the hearing itself. So I think maybe things should be handled by the municipality. And then only if, then because otherwise we would get an email or a note like these people filed complaints, or I think if the complaints are never gonna reach us, then it's because we don't wanna, because what if we get a name or something like that, we don't wanna be, let's say they get a complaint on the 1st, we're meeting on the 18th, you just have somebody's name in your head, and that doesn't, just, also for the regular reasons, you don't wanna have like in between receiving the complaint, hearing the people, all of a sudden, anybody's Googleable, you don't wanna get any pre-existing, ideas about somebody before you
So-
actually hear the information that they present to us, because they're the ones who come to us.
So are you saying you don't want to see the complaint until the hearing? Or
So
you only want to see it if you know it's coming to a hearing?
Well, I think like was said before, so as soon as the complaint is given, we say, okay, like we have our hearings on whatever Thursday of the month.
Yeah.
It's put on the tally mark there.
Yeah.
But we don't probably need to see that until the
I
day
usually
of.
send it a week before.
Yeah,
like,
exactly. So until we're preparing for that, meeting, so does that make sense?
A week before is usually what I send my stuff out.
Yeah. So I think it'd be good to hear from everybody else too, what you think about receiving copies of the complaints. You don't want them?
I don't think having that information in front of me would make me, I don't wanna know anybody's name, I don't wanna know anything about them until they talk to me, directly.
I mean, you can also, for example, if you're going to hold that information back until, a week or two before the actual hearing, I mean, I think that's okay. It's probably if a commission member wants to see it, then maybe, I mean, it's freedom, I mean, I think under freedom of information, people have a right to see it. So, I mean, it's one thing whether you initiate by sending things out to the members of the commission, but if somebody on the commission asks and says, you know, I want to know if you've gotten any complaints this weekend, I want to see them. I don't think you really can say, no, we won't show them to you.
Mhm.
But you don't have to, but I don't think you have to set it up in a way that you're going to automatically do that. I mean, you'll get a feel for the time as, well, I don't know to what extent you've gotten complaints in, but I mean, ideally, you will be able to have some fairly quick initial contact with both parties shortly after the complaint is filed, so that you'll start to get a sense pretty early whether this is something that looks like you're going to be able to work it out, or whether this looks like something that inevitably is going to go have to go to the commission. The other thing I wanted to mention, when you were talking about you might have a long hearing that goes on, and that could certainly happen if you ended up with multiple tenants from the same complex complaining about this, essentially the same rent increase. You may want to consider a special meeting to avoid having to wait a month to finish the process. It wouldn't be what you would normally do, but if it turned out that you thought that you didn't want this to drag for another month, I mean, you do have, I don't know what the exact rules are in terms of noticing meetings, but you can do a special meeting if you want to. Now, there's some commissions, I think, that operate only by special meeting, which is to say, particularly in towns that very rarely get complaints. Rather than doing a monthly meeting, they have so few complaints that they say, well, whenever we get a complaint in, we'll schedule a meeting. That only works if you don't get very many complaints. But in effect, those are all special meetings because you're not really having a regular meeting at all. It's an option if that works, but it may not. In a lot of towns, it won't work because there'll be more complaints than you can deal with, and you'd rather have a fixed time where you do them, whatever you've gotten in that month, you just do them on the same day.
Okay, so Ray and Mingo, I just wanted to check with you about just receiving complaints the week before a hearing, those complaints that are going to come to a hearing. Does that work for you? Do you have other thoughts on that?
No,
Yeah,
that
I mean-
works. That
Okay.
works.
Works for both?
Yeah,
of you?
I think if it's gonna mitigate, I mean, I don't think there's any reason for us to get it. You know,
Okay.
if it's just gonna be worked out. I mean, otherwise, if it's gonna come to us, then obviously it's gonna come to us.
Okay, all right, so that will be, what we'll follow is then a week before, if it's gonna come to the hearing, we'll get a copy of that complaint, so you have a week to look at it prior to the hearing.
And any information that I receive, correct? Rafi, if I have to send out like the building inspector for whatever reason or the
Yeah,
health.
I would send any of those if you get a report from the building inspector, I would send it out in advance of the hearing if you could.
That all would go in a package with that complaint.
That reduces some of the work. on your
Yeah,
end.
I would do that. And
Okay.
by the same token, for example, if you get a written response from the landlord, or you get other material from the landlord, you may want to include that in the packet.
Okay,
Okay, all right, good.
thank you.
One thing, I don't know what your intention is based on our conversation, but I would certainly encourage you to take another look at the handbook, and particularly the things that we talked about, to see if you want to consider making changes in the handbook. Because there are places where the handbook and the ordinance don't match with each other. And
Okay.
All right,
Yeah, that's what I was. would be my
yeah,
suggestion.
and particularly in the cases of when you're not going to take complaints, or when or if you're not going to take complaints.
okay,
Okay.
so you wanna hold off on that, or have another session in a week or two? And do
Yeah,
that?
we can, unless anybody else.
Yeah, okay, so why don't we put that on the agenda for next?
Yeah.
time
Okay.
then?
The other thing I would mention, you'll get an email on this, I hope within the next couple days. Sarah and I are doing another workshop for municipal officials and commissioners on July 18th, 10 o'clock in the morning. you've basically had, I mean, you just got the workshop. So I don't know that you want to go to the same thing again, but it'll be similar to the way we've done this today, which is that we'll do some initial presentation and then open it to questions. If you went to one of the 2 workshops we had back in February, it'll be similar to that also, but that we were really talking to people about writing an ordinance. And now we're assuming that most towns have their ordinance in place and that many have their commissioners appointed. And that our hope is that we'll get a bunch of commissioners who could not have come to the February workshops, but might come now in July. So you're more than welcome to come if you want. Again, I don't know if it may turn out that it overlaps with things. We've already had these conversations for you, so there's no point to it. But I expect it to be sort of similar in nature, which is an introductory piece in which we sort of say some basics about fair rent commissions and then letting it go wherever the questions take it. And then we're thinking maybe in September, we'll repeat it one more time in the hope that it gives us a second shot at getting commissioners in. And then maybe we're done with doing it and everybody's on their own after that.
Thank you. So at this point, I think we've finished our training. We've covered some of our old business, an initial review of the handbook based on your feedback. At this point then, because we're getting into a little bit later, I'd like to have a motion that we schedule another meeting.
Sure. What's good for everybody? Thursday nights work for everybody, but how, Rafi, do you want to stay on or are you all set? We're all set? with Mike?
No, I'm actually ready to leave. So if you would, if
Okay.
you're willing to excuse me, I will go. Once you're done with me, I'm ready to leave.
All right, thank you.
Thank you very
All
much.
right. Thank you. Look, thank you very much for inviting us. We really appreciate this. It's actually fun for us to do. And I hope it's helpful for you. And we're glad. And both Sarah and I are available, as you go along, if there's stuff you want to ask or check out on or anything like that. I mean, we can't decide cases for you, but we can answer questions because new things will arise for you all the time that you haven't really thought about. But you also have a town attorney, and it sounds to me like he's knowledgeable and interested, and that's a good source as well. Anyway, but feel free to be in touch if you want. Okay, so thank you.
Yep.
Okay.
Yep, thank you for your time. Awesome.
Yep. Bye.
Bye.
Lori, just be sure that,
What is the next one?
Yeah.
Yeah, I will.
because you already compared, which I need to do the same.
Yeah, no, I've been highlighting.
So the handbook was something that Jean created for us based on the information she was receiving. So we had nothing before, so it was a great start and it's
Yeah.
very good.
Oh,
So
yeah.
we'll just
First
tweak
time,
it a
fine
little.
tuning it.
Absolutely. I completely agree. I think that the more we get eyeballs looking at it and saying this will work or not work, or it's worded right or not, the better off. Because at some point, this might be something we just, the community needs
We
to
hand
see
off
as
to
well.
somebody else when we're done.
It'll be
yeah.
on the website once we get it
Yeah.
all right. So I
Yeah.
could direct people there.
I-
But I like the idea, what you say, let's keep the power that we have and not
Um,
reject anything.
What Thursday are people going on vacation in July?
I'm leaving July 19th for 2 weeks.
Oh, nice.
Oh, where are you going?
Greece.
Oh,
Little bit of halala hanging out.
La la.
So that would be
Jesse went to college a year in Greece.
Nice.
Study.
Study. That's what I did at UConn, Jess.
Considering how old you are, Mingo, I bet.
Is the 13th in 2 weeks? Does that work for everybody? And we'll get it done with?
That works for me.
okay.
Yeah, I'm good for that.
We're gonna start
Okay.
receiving complaints theoretically.
6:30?
6:30. I think
Do we have
6:30
any other
works.
meetings?
I don't.
Unless.
Well, I do. I have an auction meeting, but for the Y, that doesn't count. We'll do
Well,
6:30.
So
Oh, I don't.
we'll use that meeting to go through fine tuning the handbook. Any other questions you have? Because we got a lot of detail tonight.
Everybody can email me with any questions. Now, just know we're having an issue with the town's email. I can receive your emails in, but if you have a Gmail account, I cannot send it back to you.
Oh,
So I-
Why didn't Jim send an email out, telling everybody about that?
Well, I think he said something that he's fixing, like they're working on it. So it's a Google
Nobody ever
problem.
told me. It was just the park department. and
Oh, no, it's
He
everybody.
sent it
Mayor didn't even know.
So the thing is, they don't have a live person you could talk to. They have to go through a Google, so it's very difficult. So we will meet on the 13th.
Yeah.
At 6:30. I'll
There's
have
no
one.
meetings on the 15th.
that was just-
we'll do handbook, any procedural questions, any other things that have come up over the past few weeks with all the
Okay.
discussions that feel still unsettled, that we need to organize as a group, okay?
Hey, Gene, I'd ask you to consider a follow-through on our decisions.
Oh, yeah, to put
Oh,
that
you
in,
mean
yeah.
after the decision from the hearing? Is that
Yeah,
what
so if, and I'm concerned about it from both ends of the tenant and the landlord, so we make a decision, whoop-de-doo, and neither one of them follow through with it. And we end up in court as a result.
I'll work with Ned on that.
We'll talk to
Yeah.
Ned.
Because that might be an ordinance change.
That might be something I have to do after we,
Because it seemed like we're not going to court for what that guy was saying. No matter what, unless we violate procedure.
And maybe we should have it as an information sort of thing, whereas it says 30, like, it's.
It has it in
On the website, they have 30 days to comply. If somebody's not complying, please contact the town, because that kind of follows what he was saying.
Yeah,
Maybe that's gotta go on the ordinance.
it is.
and that's,
There's 30 days.
and that's what I'm thinking, Jess, is that,
So we gotta,
Well,
what
the ordinance
what
says
good does it,
days to appeal. It doesn't say, it's not talking about what you're asking, Mingo, about the follow-up.
yeah, so what good does it do as a commission if we make a decision, right? And it's a wonderful decision and nobody abides by it.
Right.
Well, we do have the power afterwards. If somebody follows up and says, oh, somebody's
Right.
not complying with this, then we can.
I think Mingo's saying somebody should, like, staff
Be more proactive
should
about
be,
it.
follow through to make sure that it's being addressed.
Right, Laura, because it sounds like we're not going to get a lot of activity.
Right?
And it shouldn't be that hard. And I think it's a way to keep the landlords and the tenants honest with each other.
Yeah. It shouldn't be hard. And like he said, to file something with the court
Yeah.
if there's something, yeah.
So if somebody starts an eviction.
Then I would
proceeding
just go
while
file
we
something.
proceed.
Yeah, so can you talk to Ned about that?
Yeah,
And then
oh,
we
yeah.
can decide how we wanna put that into the handbook, or if it belongs in the handbook.
Yeah.
Okay,
we don't like it.
all right, this was pretty interesting tonight. I got another good one.
Can I just go over, I got 5 complaints, but I want to let you know what happened. The first, well, not the first, I'm just going in order. One girl called me, her sister signed a lease, February 1st, 2023 to February 1st, 2024. The house was sold in June. The old landlord wrote to all the tenants and said all the deposits and leases were forwarded to the new landlord. A couple days after the closing, the new landlord said he was increasing everybody's rent or her rent by $350. They had 7 days to agree. So they were paying $1,500. They were increasing it to $1,850. Anyways, they spoke to the landlord, probably said they were coming here. They worked it out. The landlord is going to honor the lease for the year. And then they'll figure out. Let me see, I had another one on Village Circle, a house over there. They moved in 2021, the rental agreement was 1,700. Upon the renewal of the lease in 2022, they were given an option to renew the lease at $700 increase per month. So that would have went up. Fortunately, they were able to negotiate to 2,100 a month. This year, the same thing happened. He wanted to increase it to another 700 a month, which would have brought the rent to 2,800 a month. So what happened was he decided he went and looked for a house to buy. So he's put an offer in a house in Prospect. So that one went away.
It's cheaper to own at that point.
Yeah, if that 700 a year increase each month, I mean, Mingo, we have you as a landlord. I mean, 700 a month increase 2 years in a row.
Well, I think the problem that you face is that landlords are looking at what they could get if that place was empty.
Right. Instead of what their tenants like, their current tenant.
Correct. And I think that's the disconnect. And, you know, I struggle with this because if the market says it's $100 and you're paying $20, who is that fair to, you know?
So, yeah, so that's why we have to see each individual, like what he said in his letter is nothing was updated. The windows were old and leaky, the whole bit. So anyway, so that one was done. Another one came in, a guy called for his mother-in-law. She lives on Osborne. When they were renewing leases, the new owner, they were gonna raise the rent $300 each month. She's on a fixed income, so she ended up going over to the Housing Authority, got her name on the list over there. He says there's been no increase yet, so they haven't come forward with anything. Something with, I don't know what this one was, but the social workers getting involved with this one over on Carroll Street, so I have nothing with that one. And then they gave me an address, 69-5 Ridge Road, that's it, from the mayor's office. So I can't do anything with that, that's nothing. So at this point,
Yeah, until we have the
you know what it is?
actual form for submitting complaints.
So this is, yeah, I was gonna use the form that we had because Ned says we could tweak it after if we have to, so.
Once we get rolling, probably schedule one meeting a month, and if we don't need it, we can't.
Correct, I
Yeah.
could get you do like we do with the regular commissions. And this way, then they're not special meetings. With a special meeting, we can't add anything to the agenda. But if we have regular scheduled meetings, we could add if we had to. So,
Okay,
all right,
okay.
all right, so then our next meeting, and then at that meeting, we're gonna decide what Thursday do you like?
Yep.
I'll find out from Janice when this room's available. I think this room works the best. And we have the nice big TV.
Okay. So we have a motion
I
to
would
adjourn?
have
Second, all right, thanks, everybody, we'll see you.
Thank you, everyone.
Thank you, thanks for joining with Zoom.
Well,